While that's happening, I'll start our introductory remarks. Just a reminder that our conversation here today is just for general information, not legal advice. So make sure that you're not relying on it as such for your particular association. If you have specific legal questions, ask your attorneys. And also in that vein, remember that the chat function is intended just for questions and general commentary, not legal advice as well. We have a lot of questions today and have had for a while on the CTA, the Corporate Transparency Act. It is still being challenged by the National CAI. We're still recommending waiting until later this year to comply if you can. The deadline is not until it is January 1st of 2025 to comply. We note that there are some management companies and law firms that are offering to report for folks. There are significant fees involved with that. We think you can complete the reports yourselves, and the process is new, but it's not complex. So, and it doesn't require any legal expertise or anything like that. We have noticed that there is kind of an aggressive ramping up lately on pressuring clients to sign on for services that may assist you with that. So just keep an eye out for that. I did want to say thanks to those of you who we saw at CA Day this past Saturday. It was very well attended, and it was great to see some of your faces in person and nice to catch up with you. So it was a good day, and happy to have seen some of you there. Ken, unless you have anything else to comment on, I think I'll get started.
Okay, go ahead.
Great. The first question, can board members file for the CTA on their own? If so, can they manage the account on their own, such as the annual renewal and/or the update changes to the board members? And the short answer, as I just said, is yes. There's no need to pay anyone to do this. The process is pretty straightforward and simple, and especially if the board members or the individual board members sign up and get their own FinCEN number. And then they provide it to whomever the board has decided is the reporting person. It could be the secretary or whomever wishes they decide to do that. We talked with some clients at CA Day that if you have particularly unsavvy computer unsavvy board members, it may be nice to offer a working session where you're helping them sign up for their FinCEN number. It's not a hard process. The information you're providing is information the government already has. All you're doing is linking that information to this association. So it's certainly a simple process. We've also considered have recommended to boards to consider adding on their agenda, their monthly board meeting agenda or quarterly board meeting agenda whenever you meet, to make sure that you discuss the CTA, because if you have a board member leave or a new board member added in the interim, you do have 30 days in which to report that information and update the FinCEN information. So just make sure that if you are in charge of reporting on your own, that you are making sure you have processes in place to make sure that information is updated timely. And again, the deadline is not until January 1st of 2025. So please don't panic. You have time. It's not a lengthy process. And we do think you can do this yourselves. Ken, anything to add to that?
No, I think we're beating a dead horse on some of
I
that.
think so too.
So the next question is, if a board member resigns mid-year, does an amended annual report need to be filed with the Secretary of State, or can the update wait until the next annual report is filed? So we assume you're talking about the registration with the Secretary of State for the nonprofit corporation and the list of the board members or directors, which is included on the Secretary of State's website. So you are required to report annually, and there's a requirement that it be accurate when you report, but there doesn't seem to be a statute which requires that the Secretary of State be made, or that report be updated as changes occur mid-year. On the other hand, it makes sense to update it during the year because for some purposes, that is the sort of legal record of who represents the association. And there are banks and other businesses that will go to the Secretary of State website to confirm that the persons who are conducting business with them are entitled to do so on behalf of the association. So we would normally recommend that you update or try and get the cycle of when you report to line up with when you do your elections every year so that you can take care of it accurately once each year. It's one of those things which probably doesn't come up a lot in terms of being important, but it does, you know, the Secretary of State website is how you represent to the public who is authorized to make decisions on behalf of the association. So we would normally recommend that that information be kept accurate. Anything you want to add, Lisa?
Nope, I think that covers it. The next question goes back to the CTA, and the question is, our board would like to require that all current board members and newly elected members must obtain a personal FinCEN number and supply it to the board in order to serve. In the case of a newly elected board member, this must be done within 15 days of the election. That's the proposal. Can we do this with a rule, or would we need to amend the bylaws? If we're stuck with the CTA and a bylaw amendment is required, would CLG be developing one at a flat rate? I'll answer that first, the last question first. A bylaw amendment would be a bylaw amendment, and it would be whatever the rate your attorney charges for that. There wouldn't be a specific one for adding a FinCEN requirement for the CTA. But to answer the rest of the question, it might be reasonable, since the job of the board is to run the business of the board, to have something in your bylaws or your rules that requires compliance with local, state, and federal laws, which might include providing the necessary information or the FinCEN number so that the board can function and provide its annual federal reporting. You could certainly adopt it as a rule. Then the question, I guess, is how are you going to enforce that? Is this a fine? And if your intent is that the person could not remain on the board, I don't think that's an appropriate use for, I don't think you'd be able to do that wouldn't be able to do it with a rule. You could specifically state in your bylaws, if you wanted to amend them, a remedy for failure to comply and what that would be, whether it's a forced resigning from the board or something like that. But if it was in a rule, a remedy like that would not be enforceable. Again, you could do something like a fine. If you don't have an amendment to either the bylaws or your rules that requires a board member to have a FinCEN number and provide that to the board for reporting, you could do what we've talked about in prior Q&As, where you have a special meeting to remove that board member because they refuse to comply with a federal law. As I said before, this information is already with the government, so it's hopefully you're not having board members or dragging their feet about providing a FinCEN number, which isn't their personal identifying information. Hopefully you're not, hopefully this doesn't become a problem, but yes, I think you do have potential mechanisms for enforcing this type of a requirement of board members. Anything you want to add, Ken?
Well, just again, a reminder that the FinCEN number is a way of preventing your neighbors from having your personal financial information. So you can comply with this statute without having to give any information to any of the board members or other owners or manager, because you can give it directly to the government and you get something which functions the same as a social security number, but is not your social security number, that allows the government to tie the your personal information to the association basically in secret from the rest of your community. So next question. We had a homeowner at a recent board meeting for an association governed by WUCIOA assert that there were recent changes to the statute that prevent the board from knowing the names of owners who submitted architectural applications and for compliance matters. We're unfamiliar with such change. Can you confirm if board members are restricted from the names of owners for ACC applications and non-compliance letters? So we don't think that the board is prohibited from knowing the names and specific lot or unit number that has made any ACC request or for dealing with any non-compliance letters. We don't know what what someone could have thought would create this. In part because we don't think that a board could evaluate an ACC application or non-compliance letter adequately without knowing the specifics, which would include the lot or unit and probably the owner as well. I suppose it might be possible that you had an independent architectural control review committee that might evaluate applications, but in most cases, the board is ultimately who has the authority over such a decision. And the board certainly is who has the authority to decide about whether or not enforcement and compliance need to be dealt with. So I think that it does not make sense to say that a board could not see that information. Now, there may be a different answer with regard to other owners who are asking for information about that, because the statutes that relate to records do now specifically require that information be redacted that would try and get this correctly. So the statute says that information must be redacted that relates to individual unit files other than those of the requesting unit owner. So that is in subsection H of the WUCIOA version, which is RCW 6490-495. The WUCIOA statute is a little bit different from the other three right now because of amendments that were made to WUCIOA on June 6th. But that mostly relates to the secret ballot provision, which was added to WUCIOA. It doesn't change the provision related to unit files, which is in all four statutes. So if the question is, does a board member have a right to know who has made a request or who is being disciplined, as it were? I think the answer is yes, the board has to know. If the question is, do all owners get to know? The answer would be no. The information has to somehow be redacted. We don't know whether that means you refuse to give all architectural control or architectural requests for all units when requested, or you have to provide the information in a way that prevents identifying the individual lot or the individual owner. So if someone makes a request to review all of the association's records related to new gazebos being requested in backyards, I don't know that you can just simply say, no, we don't give out any of those. You may have to find a way to give them out, but protect the identity of the individual owners. And that's, something that has not yet been drugged through the courts. Any other comments, Lisa?
No, just that if folks want to learn more about the records stuff, we've talked about it in other Q&As, and you can certainly do a search on the YouTube channel for a more intensive discussion about that. Next question. Thanks for explaining last week that the interest earned on CDs in the reserve fund is actually operating fund income until the net gets transferred into reserves. Can you explain how that works? Each bank statement shows new interest on the CD, so the CD balance increases, which increases the reserve fund. Is it okay then to simply transfer the interest from the reserve fund savings account to the operating fund checking account where the interest belongs? I will first say that this is really a question, I think, for your accountant or your bookkeeper, because the bank is not preparing the association's financial statements, and how the bank is accounting for interest is probably different, or it certainly is unrelated to how your accountant may account for interest. It is possible that a bank potentially could credit operating account with the CD income, but that is something you'd have to talk to your bank about, but certainly talk to them in concert with or after you've had a conversation with your accountant or bookkeeper about how this is going to be allocated in your records. I think that answers the question. Ken, anything I missed there? That was a short one.
Yeah, just that, the banking industry doesn't really care about your accounting.
Right.
They certainly don't care about the statutes which require two signatures to withdraw funds, because even though that's been in the statute for decades, I don't know of a single bank that wouldn't issue a check with this one of the signers that has been authorized writing a check. So, we cannot sort of fix differences between how the legislature or the generally accepted accounting principles might say something should be done and how your bank actually does it. So, next question. Is it allowed to allocate the amount of a special assessment by the length of time that an owner has had a condominium? We all pay the same amount for our monthly dues. If so, what code addresses this? So the short answer is just no, you cannot assess any cost based on time. You can only assess based on the percentage of ownership interest as shown in the governing documents at the time of the assessment. Okay. So we don't know what code you're talking about or are organized under. We assume you mean the RCW, which would be either the Homeowner Association Act or one of the condominium acts. But again, it's the allocated interest at the time the assessment is due. It's not even the time the assessment's made, it's time the assessment is due. So if a unit sells, the new owner at the time it is due is responsible for the payment. So RCW 6490, the WUCIOA 480, section 3, basically says, except as provided otherwise in the section of the code, all common expenses are assessed against all units in accordance with their common expense liabilities. And the liabilities are called out specifically in the declaration or CC&Rs. In most cases, it is the percentage ownership interest if it's a condo, or it is equally per lot if it is a homeowner association. Okay. There are exceptions which can be written into the governing documents. If they're not there, then you don't get to make an exception. One of the exceptions is like utilities. And another exception might be something like cable TV, which the declaration may allow you to charge on a different percentage than as provided in the declaration. Anything you want to add, Lisa?
No, I don't think so. Next question. It seems clear that WUCIOA's strict open meeting requirements prohibit voting electronically between meetings and then ratifying any motions that were approved unanimously by email at the next regularly scheduled board meeting. What options do we have if we want to amend our declaration to adopt everything else in WUCIOA except for this provision prior to 1/1/2028? Is there a way to adopt WUCIOA with this exception prior to 1/1/2028? And would we be able to carry that option forward after WUCIOA becomes universal in January of 2028? I will say that it's always, we get these questions a lot about trying to make things unavailable to other to members from board meetings, and so we always kind of wonder what are you trying not to disclose to your owners. But generally speaking, if you adopt WUCIOA, you adopt WUCIOA in full. You could certainly adopt provisions of WUCIOA early if your board and if the association wants to spend money on amending your declaration now to adopt the provisions of WUCIOA that you do want to adopt. But know that when the full WUCIOA for all goes into effect in January 2028, that the provisions of WUCIOA as it exists at that time would be, you'd be subject to those. So you can always spend money to amend your governing documents to do things that comply with the parts of WUCIOA that you want to comply with at this point. But know that under the statute, the prohibition, as you're stating, against voting by email is only for things like anything other than a ministerial act. So you could still have an email vote on things that are just basically ministerial, which unfortunately is not defined, but we take to be sort of general business things that, general things that the association would need to do. And then I want you to keep in mind also that what we're telling you is what the statute says, and what the best advice is on how to follow it. There are risks to not following the statute and not complying with the information in the statute. It doesn't mean that an association couldn't continue to vote by email after WUCIOA goes into effect or if they adopt WUCIOA. But know that it is technically a violation of the statute. I also point out, and I think we've talked about this before, that the only person who can object to the association voting, for example, by email or doing something that is not something like that, is an owner. And to do that, they would have to file a lawsuit against the association within 90 days of that decision being made available to them. So it is likely that if a decision is made and no owner objects, and 90 days has passed and the owner understands that decision is not ripe or able to be objected to anymore. So that's sort of a long way of saying you can't exclude, if you're going to adopt a WUCIOA as a whole, you can't exclude certain provisions of it. If you want to adopt what you want to adopt, go ahead and do that. Nothing to prevent you from spending the money doing that. But also know that, we're telling you what is in the statute and the information you need to know to be fully compliant with it. But certainly talk to your attorneys if you have specific questions about things you're doing and how your attorney can help you to enforce or to proceed with that. Anything I missed there, Ken?
Well, there's some things you can adopt as procedures for your community, which are included in WUCIOA, and some things which you could not because they're specifically a statutory requirement that
Sure.
requires you adopt WUCIOA. So my example would be the statute of limitations. If you're a condo and you want the 6-year statute of limitations, or you're an HOA and you want the super priority lien, you can't get that by just amending your document and not adopting WUCIOA along with it. Whereas you can do a lot of procedural things by, so you could adopt a voting provision that matches WUCIOA in your bylaws without having to adopt the statute, because that is a procedure which is within your authority under the current statute. And so sometimes if you're looking at a specific provision you want, it's going to be dependent on the particular provision and how it's affecting you. So we've had clients adopt WUCIOA just so they would get the borrowing authority. But under the Condo Act, you can adopt an amendment to get the borrowing authority all by yourself. So you don't need to adopt WUCIOA. You do need an amendment to the declaration. And then something we'll talk a little bit more later maybe about is, the comment that associations are going to continue to make decisions via email, and we know it. It is just too efficient and easy, and the requirement to do open meetings for every decision, as much as it may be, I'll say, a valid right of owners to know what's going on. I also recognize that the legislature put into WUCIOA with this strange provision that says a decision of the board can only be challenged for 90 days after the decision has been distributed to the owners. And all I can think is that that is an acknowledgement that there's going to be a lot of procedural failures or procedural non-compliance by associations, and that the legislature has put in a specific sort of savings provision that all those decisions are still valid if they are not challenged promptly by the owners. And so if you adopt a new rule about pets and you don't give owners advance notice and you don't give owners a comment period, and you just do it and you mail out the new rule about pets, under this savings provision, if 90 days goes by and the owners don't challenge it, then the rule is going to be enforceable. And so, as attorneys, a lot of what we're looking at is when you want to enforce something, you want to make an owner do something like pay their dues, we're going to need to have proof that you followed all the procedures adequately. Because if we don't have that, then we get challenged in court. And so we're pretty strict about wanting the notice provision for your budget to have been adopted correctly. But we also recognize that, today, many associations are not following all the requirements of statute. They're not all getting reserve studies and audits. And, there's no condo police that comes out and finds them and makes them do it. And there won't be any condo police to come and make you hold open meetings or provide comment periods. And if you don't do those things, then you may need some assistance from an attorney to figure out how you can enforce what you want to enforce. And the answer may be we tell you to go back and do it over, or it may be we can tell you that enough time has passed that you'd be able to enforce it even though you did not follow the procedures correctly. And remember that this savings provision with 90 days doesn't exist in the other statutes. It is only a WUCIOA provision. So if you're failing to hold open meetings for a homeowner association under the HOA Act today, there isn't a savings provision the way there is in WUCIOA. So I know that's a long-winded answer to sometimes it just doesn't matter. Anything else you want to add, Lisa?
Nope, go ahead with the next one.
Okay. Are unit owners entitled to receive a refund of any excess monies in operating funds remaining at the end of the fiscal year? Basically, this is a question of ownership of HOA operating and reserve funds. So I'm going to say that the short answer is that some declarations and CC&Rs do require that refunds be made or special assessments be made if your actual expenses and income do not match the association's needs. There's no statute that requires that I'm aware of. The association would normally take a surplus and use it to offset the next year's expenses, or they would transfer it into reserves, which are usually well underfunded. And so the surplus is simply going into the association's account. There's certainly no, I'll say, question about the ownership of reserve funds, because those are basically held by the owners in proportion to their ownership interest, the same as any other asset. It's only the operating account where you've collected money for current expenses where maybe you've got a surplus or shortfall where this might apply. And, my opinion is that it's a lot of accounting and work to try and refund or special assess a small amount of money. I've got a couple clients that have documents that require what they call reconciliation if the actual is more than 3% above or below the budgeted expenses. And I think that's a pretty narrow window for most associations. And I recommend against trying to recalculate everyone's assessments after the fact, because it's an accounting nightmare. So I don't know if you've got any other comments, Lisa.
Well, so Ken, if it's not in your governing documents, what's the best way for an association to, would they just create a board, just create a policy? Would they put it on the budget saying if we have extra money, it goes to next year? What's your recommendation for an association?
Well, as part of your financials, which you are providing to the owners, because you're required by statute to provide the financials, that will show if there actually is a surplus or deficit in your operating funds. So it's not that the owners are not informed. They know that. And so most associations are automatically putting it into reserves. If you want to avoid treating it as a tax consequence, there's a special IRS ruling that requires that the association vote to transfer the money from operating into reserves. I can't remember the IRS opinion number on that, but technically every association should be voting to move any surplus every year, and their CPA may advise them on that. So I would say it's a board policy. I don't know that it has to be written into any of the rules or the bylaws.
And it would certainly be evident in the next year's budget, would show that income, I guess you'd say, right, where it was going. Okay, next question. I have a client, which is an old master association community with all of the owners in each of the 15 residential buildings, and each building is its own old act sub-association. The master association wishes to adopt WUCIOA and restate their declaration. Do all of the sub-association buildings have to adopt WUCIOA as well? And I can give you a short answer to this, which is no. Each association has its own declaration. Each association has its own governing documents. And although the subs are subject to some of the restrictions and potentially assessments of the master association, they don't have to have one governing or similar governing documents under similar statutes. It probably would be easier, but it is, if you've got 15 sub-associations and a master, that might be hard to, it's like the old adage of herding cats, trying to get everyone to agree to adopt WUCIOA at the same time. There are specific provisions in WUCIOA, as there are also in the Condo Act, that relate to master associations. So, and how they function. So that's certainly something you may want to review. You also may want to review whether or not or how these associations have related to each other over the past years, and whether they're actually run as one association or if they are in fact run as 15 separate associations with a master. Because it may be that the community decides to merge all the communities into one association. You could do that and still have each association or still have each building responsible, as we were talking about previously, with its own maintenance expenses or something like that. I don't know enough about your situation to know if it makes sense to do that, but that is certainly something that the association may want to talk with its legal counsel about. But the short answer is no, they do not have to all be under the same, don't all have to adopt WUCIOA at the same time. Anything you want to add, Ken?
I had a client in the last couple of years, which was very similar. They had been functioning as a single association, and did not sort of understand that they had 15 different separate condo associations that had been recorded with the county, and they had let all 15 of those condo associations expire with the Secretary of State because they didn't understand how they were set up structurally. And so we merged them all into a single entity with the revision to their master document. So it's they had spent decades disregarding the 15 different sub-associations. And so we were able to make a good legal argument that they had abandoned that structure, even though that's what the county records reflected. So, we were trying to make the documents match their custom and practice rather than force them back to functioning the way the county documents showed. All right, next question. Since vendors are supposed to file an I-9 report with the government regarding the status of their employees, what liability does an association have if a landscaping company utilizes undocumented laborers for fulfilling contracted services to the association. So I'll say the general answer I have is that the association would have no liability for workers if the company they are hiring is properly licensed with the state and or federal government. So you don't have responsibility for knowing if the employees at Target are, documented employees when you go in and buy goods at Target. If you are hiring a licensed contractor, you can assume that the contractor has all the liability and responsibility for making sure that their employees are legally working. You can certainly look to put a provision in a contract that would further protect you if you want to. And you could have an attorney help you in reviewing the association's contract with a vendor to make sure that you are adequately protected. But it's not your responsibility as a customer to confirm that the workers with a contractor you hire are properly documented with the federal or state government. If you have a specific concern about a vendor, you might want to talk to your attorney about it. Lisa, anything to add?
Just that the only issue would be you want to make sure that that contractor is properly licensed, and then it's fine. But if you're not checking that, that may be an issue. Next question. Is there a management company condominium board privilege for association business related, for board privilege for association business related communications and documents? And I struggled a little bit to make sure I understood this question. If you're asking whether the manager or agent of the association is a part of the attorney-client privilege that the association may have with their legal counsel, the answer is probably yes. As an agent, as the person hired and working on behalf of the association, the manager themselves is probably a party to that attorney-client privilege and doesn't break it. Whether if they're spreading the information around their company, that I might have a different answer. But if that particular person assigned to work on your particular association and in on the meetings with your attorneys doesn't break the attorney-client privileged. If you're asking about, generally speaking, about the documents that are created between the association and the management company, and whether or not those are records of the association that could be discoverable, so let's say in a litigation, or have to be turned over in a litigation, that question becomes a little more complicated. There's an open question about whether or not emails between the association and their manager are records of the association, which are subject to disclosure. There's also a question about whether emails between board members are association records, and we believe they are not. But if the board is discussing business and making decisions via email, they know that that information could potentially be discoverable in litigation or need to be turned over as a record under WUCIOA or under whatever condominium or HOA act you are governed under at this point. So there's a risk associated with email business. Whether those documents are subject to discovery under court rules, they probably are. It may be an open question, but they probably are if you're involved in a litigation and the request is for documents related to X, Y, or Z, and those things are in emails, that is probably discoverable. There isn't a statutory protection for that communication. There isn't a court rule that says that is protected. It's not the same as an attorney-client privilege, if that's what you're asking. That's a very specific privilege that exists between an attorney and their client. That same privilege exists between a managing agent or management company and the board. But as a general rule, and because of that, as a general rule, we would advise you to assume that any communications are subject to review by owners if they make a record request or if there is a litigation. And again, we talked a little bit about the potential exceptions that may be there in WUCIOA 6490 495, so section 3, and similar language in most of the other acts as well. But so the question is, if it's an attorney-client privilege question you're asking, or if it's is the information private that's between the manager and the board? Those are two separate questions. I think if the board is talking to their manager, assume that that information is probably a record of the association that may need to be disclosed if an owner asks about it, again, subject to the redaction exceptions in the statute. Anything you want to add, Ken?
Well, yeah, I'll say what adds the confusion is there are two separate and distinct sets of, I'll call it regulations about records being reviewed. One is under the statute, and it relates to the relationship between an owner and the association. The second is under the court rules, and it specifically relates to how documents are protected or not in litigation. So absent litigation, the court rules don't apply, except that we would still tell clients, don't provide information which is protected by the court rules. So that's why the attorney-client privilege can be applied even if you're not in litigation. The challenge is that the statutes which regulate the relationship between the association and the owners do not discuss communications between the board and manager or the board members directly. So our assumption is, because it's not one of the protected communications, that you may have to provide it under a records request. Well, I suppose you could also refuse to provide it and require that the court issue an order stating what the interpretation of that statute is. Anyway, it's not an easy question, and that's why we do say just assume that the information is going to be shared. Don't say things in emails that you don't want to be aired publicly. So we're to go on to some questions that actually came up from us during CA Day instead of submitted by clients. But one is, what is the difference between an absentee ballot and a proxy? One of the speakers at CA Day said they are the same. And my answer to that is that an absentee ballot is specifically provided for by statute, and it must be prepared by the association and sent to the owners with the notice of a meeting where the vote might be taken. It allows an owner to vote without attending the meeting. It allows the owner's ballot to count towards a quorum, and it will state exactly how the owner wants their vote cast. A proxy allows an owner to give their vote to another person who attends the meeting. It can be prepared by the owner or the association. It does not need to be provided by the association. It does not need to be sent out with the notice of the meeting. And it typically would not specify exactly how the vote is to be cast. It would give the vote to an owner. A proxy would allow the holder of the proxy to vote on a motion which has been modified at the meeting. So let's say there was a motion to allow a new gate for the driveway to be installed for $50,000, and a motion was made at the at the meeting to change the dollar amount from 50,000 to 60,000 because of sales tax or something. An absentee ballot could not be cast for the new dollar amount. It could only be cast for the original dollar amount, whereas a proxy would be allowed to vote on the new dollar amount if that motion to increase the amount was passed. So an absentee ballot is not the same as a proxy. One has a very specific statutory requirement for how it is prepared and how it is given to owners. The other has a statutory requirement for the information the proxy must contain, but it does not state the association has to prepare it. Lisa, anything to add?
Well, I was just going to say that I just want to make sure, because we often get questions about this, the board can't use proxies. This is only for owners at a unit owners meeting. The board can't assign someone else to vote for them as a board member.
That's
As an
correct. The
owner.
board member cannot vote by proxy at a board meeting.
Right.
So one board member cannot give their vote to another board member in order to conduct business.
I've gotten some questions on that, so I want to make sure I clarified.
Thank you.
Next question. At the Mock Association meeting at CA Day, the board president made a motion to adopt the special assessment proposed by the treasurer. Is a motion to adopt required? And this question is particularly appropriate because we're embarking on budget season. So we want to make sure that when you come to me to collect past due assessments or special assessments, I can do that and you don't have to re-ratify your budget. And so the answer to this question is a motion is not required. A motion for the budget or the special assessment is not required to adopt. Because remember that the statute says that if at least 51% of the voting power is present at the meeting and votes to reject the budget or the special assessment, that's when the budget might not be ratified. But a member could make a motion to reject the proposed budget or special assessment, but you don't need one to promote or to move forward the budget. Any votes that are cast shouldn't be yes or no because that's confusing. They should be reject or accept. And again, the board, nobody needs to make a motion. They could just ask if someone wants to make a motion to reject. They also don't have to do that. They can just say, this is the time for the budget ratification. And if no one so moves, then the budget would be ratified. Anything you want to add there, Ken, that I missed?
No, I think you're covering it. Just a different way of saying it is that if you do a motion to accept and there are more no votes at the meeting than yes votes, you're going to have a lot of owners who are convinced that the budget has been rejected, even though there aren't enough no votes to meet the 51% requirement for the entire voting power. And so our recommendations typically don't have a vote if you're not required to. Only call for a vote if there is a motion from somebody and a second, because if there's no second, the motion fails. And so if you've only got one objecting owner, even if they're, being formal and making the motion to reject, if they don't get a second, you don't have to take a vote. Number 3, can the board prohibit owners from making comments on topics that are not on the agenda for a meeting? And the answer is no, not under WUCIOA. Because under the specific language of WUCIOA, an owner is sort of guaranteed by statute the right to comment to the board at a board meeting and the right to comment to the association at an association meeting, and they can pick whatever topic they want. You do not have to respond to their comments. You do not have to answer questions. You do not have to take a vote on something that's not on the agenda, but owners have to be given the right to stand up and basically state their piece. Anything you want to add on that, Lisa?
No. The next question we had is pretty much the similar discussion to our 90-day objection period. Do we still want to go ahead and talk about it, or?
No, I think we're good with that. So
Okay.
if there's questions from people in the chat, we could do those.
Yes, we do have a couple. So first, on CTA's beneficial owner report, would officers who are not voting board members, such as treasurer or secretary, need to be included? Would a board member alternate who votes only in a director's absence need to be included?
Well, to be safe, I would say include them all. In part because there is a lot of uncertainty about how the law is intended. In most communities, the officers are all directors. They are elected also, so they would be voting board members. I do understand there are some communities where the officers are not part of the board. But again, I would say the safe thing to do would be just include them all. And as to an alternate, as much as I think there should not be such a thing as an alternate, if you've got one in your bylaws, I would say if they ever get to vote, then they would have the same requirement to report under the CTA. And certainly if you're concerned about compliance and you want to be following the letter of the law, you take the most expansive view of who would be reporting and include them all. Any other thoughts, Lisa?
No, just that there are real penalties for not complying, so I don't see the harm in over complying, I suppose.
Yeah, we also don't know how much the threats of $500 a day for fines actually mean there will be any fines. There may be a strong effort to have an incentive for people to respond, which may in the real world not come to pass. I don't know that Congress would be supportive of 80 million people being assessed fines of $500 a day for failure to comply.
You're muted, Chelsea.
How would a condo association fall under being 501c?
So there is at least a potential that you are a 501c subchapter 7, but a condo association cannot be a 501c3, which is a charitable nonprofit, and you cannot be a 501c4, which is a corporation formed for the public good. The IRS has made it very clear in an opinion that unless you are promoting activities for the general public, meaning non-members of your community, you cannot qualify as a 501c4. So a community like Klahani, which may have public parks, which they allow non-residents to use, might qualify as a 501c4. Every other homeowner association, if you are restricting use of your common areas to the members of your community, cannot qualify as a 501c4. So it is not possible to get an exception based on the 501c status.
All right. If the association has debt piling invoices, can their recurring services such as janitorial or landscaping service be paused until they can come up with the funds?
Debt piling, I'm not sure what that means, but Lisa, you get this one.
Well, I think they just mean they don't have the money to pay for their services, and can they stop the services until they have the money to do so? I mean, that to me sounds like they are in need of a budget a budget meeting and stat that provides for payment of all ongoing services. But I guess the question is, can they just stop taking care of the public spaces until they have the money to do so?
Well,
I don't.
I guess there's two ways I might interpret the question. One might be if the association does not have enough money to perform its budgeted services, can it stop doing them? And so if you don't have money to pay the landscaper, yes, I guess you stop hiring the landscaper because you don't want to go into debt as an association. If your question is specific to individual owners, so let's say the association mows the lawns for all of the communities, which is, we have communities that do that, where every front lawn in front of the homes are maintained by the association. Could you stop mowing the lawn for the delinquent owner? You probably could. Under WUCIOA, you can stop providing common services, and you can take away the right to use common elements from a delinquent owner following notice and opportunity to be heard, a key step, but only if it does not affect the ability of the owner to reside in their unit. So things like utility termination, we believe, are not allowed anymore under WUCIOA. or the Condo Act for that matter. If taking away a service prohibited an owner getting to their home, then you could not do that. But if we're just talking about you stop mowing their lawn, I think you could probably do that.
Or they couldn't use the
Sure how
pool or the
that benefits
cabana.
the community a lot, but
Yeah.
any other thoughts, Lisa?
I've certainly seen declarations that aren't subject to WUCIOA that restrict access to delinquent owners to things like the pool or the cabana, that kind of thing. That isn't necessarily on point to this question, but that certainly is possible.
All right, so next, for an account within the operations fund, if overfunded, must the board notify owners if they use that for another account, i.e. by meeting minutes?
So I would suggest that it is reasonable for the meeting minutes to reflect decisions which make significant changes in both income and expenses from what you had budgeted. But there is a court case, I think out of Eastern Washington, where basically the courts held that a budget is just a budget, and the discretion of the board to reallocate funds within that budget is pretty much unlimited. So if your garbage expenses are too high and your landscaping expenses are lower than expected, you just reallocate the money. As long as you are not changing the total assessment to each unit owner that you are collecting every month, the board can spend the money however it needs to keep the association operating. And the case that it came up with was one where the board had proposed a fairly significant increase to maintain services. The budget was rejected. The association just, the board changed really significantly what they were paying for in order to keep the necessary services going. They were sued because they were not providing the services that were originally budgeted. And the court basically said, look, the owners rejected the budget that was proposed. The board did what it needed to do, and the board was within its legal rights. So hopefully that answers the question.
And I would say that to answer the person's other question about meeting minutes, that would make sense, because then if the board is voting at a meeting to allocate money from the pool budget to the landscaping budget or whatever, or invoices, that would be a motion, and on the at the meeting, it would be in the meeting minutes, and owners would have access to that. You'd hope the president wasn't making these decisions by themselves. Anything else, Chelsea, in the last 2 minutes?
Yes, follow up on proxies. Is there such a thing as an irrevocable proxy?
Well, I would say no, there's not such a thing as an irrevocable proxy. The owner would always be able to, terminate the proxy which they have provided. There are some specific rules. If the proxy does not state when it terminates, by statute, it terminates at 11 months. Yeah, I guess that's the answer, unless you got something different, Lisa.
Nope, I was just going to say the 11 months. Nope.
Quick question for clarification on the percentage required for budget approval. Was it 51% or 67%?
There is no requirement for budget approval. That's the key. There's
But it's
no
51%.
requirement for budget approval. There is an ability for the membership to reject a budget that has been approved by the board, and that is a minimum of 51%. And the number to reject may be higher in the governing documents.
I was just going to say I have a client who's 90%.
So the percentage for budgets is to reject, and it's a minimum of 51%. All right, well, I think we need to thank everyone for attending today. And if you've got questions, please submit to info@condolaw.net, and we'll get them next week.
Thank you all.